I'm here with Rob Van Esch with the Van Esch Law Firm. He's been a real estate and business attorney for 16 years. The guy has tons of experience in real estate matters, dealing with HOAs, etc. And we're here to talk about a specific new set of laws that will allow California residents to put ADUs or accessory dwelling units on their properties. And I'm here with Rob because he knows more about it than I do, and I want to give you the best possible information so that you could proceed accordingly. Rob, how are you?
Doing well, Colin. Thanks for having me.
Thanks for coming on. I really appreciate it. So we're here to talk about this new ADU law. I'm assuming you probably know a little bit more about it than I do. Have you had a chance to take a look at it? What are your thoughts on it? And what are the new laws that are going to come into place that are going to kind of might be challenged?
I've had a chance to take a look at it. I mean, in a way, how could you not by now? Everybody's talking about it.
Right.
You know, I mean, if you're involved in real estate in California, you've heard about it
Totally.
at this point in time.
Yep.
Everyone's excited. Some people are scared. I think it's going to be a good thing personally for, real estate. What essentially it is a law that allows you to convert your garage into a dwelling unit if you want to, and then you can also build a separate structure somewhere else on the lot. Probably conventionally, it's going to be in the backyard.
So
for
two
most
possible
of us.
units,
Yeah.
in addition to your current primary residence, making it, in essence, a triplex.
You could basically have a triplex, and if you have a multi-family unit, such as a duplex, you could actually build two detached ADUs in the lot somewhere. Plus, I would imagine you could still convert out the garage, because there's nothing in the statute that says that the part that allows you to convert out the garage would not apply to the multi-unit dwelling units. So
that's a lot of units.
You might have, if you have a duplex, you might have 3 or 4 additional units on the property.
Wow, that's incredible. So there are, I'm assuming, currently laws in place in most residences or most cities that would prohibit this type of construction. And so you're telling me that these new set of laws are going to make those other laws obsolete, essentially? Or how does that work? What's going to happen? HOAs, CC&Rs that are currently in place, what's going to, what do you foresee happening with those types of structures?
Yeah, good question. And let's take it in 2 steps. Let's go 1, what about the governmental regulations? And then 2, let's get into the HOAs.
Okay,
that's
sounds
kind of
good.
a different conversation.
Perfect.
So as far as the governmental regulations, for a long time, there have been rules in place that made it very difficult to build an ADU. For example, there might be a setback requirement.
Right.
Some cities might say, well, we are going to require as much as a 20 to 30 foot setback in order to build a secondary unit or an ADU. In which what that means is essentially that the edge of the ADU must be at least 20 or 30 feet away from a neighboring property.
Gotcha. So that could prevent them from building an ADU there generally.
And it was a very effective way of essentially clamping down on that and making it very difficult to do it unless you had a type of property that was a very large lot type of situation.
Right.
So average, for example, Orange County, Southern California, it was pretty difficult to do it.
Right.
So you probably have your average lot here that might be 12,000 square feet, and if you've got a 4,000 or a 3,500 square foot home on it, which, for example, in Yorba Linda, which is just down the street from us, that's kind of what you see all over the place. It'd be very difficult to stick, let's say, an 800 or a 1,000 square foot, 800 square foot or 1,000 square foot ADU in the backyard with those types of requirements. So that is a great example of what this new law is doing. It's clearing the deck. Now they're saying you can't have these minimum square footage requirements in place to prevent people from being able to do that. And you also can't have these setback requirements in place that prevent people from being able to build the ADUs. So the law actually said you can't have a minimum square footage requirement for the ADU, and you cannot have a setback requirement that requires a greater setback of more than 4 feet. So now that's kind of straightened out for us.
That's basically a walkway. So,
yeah, I mean 4 feet, right? I mean stretch out your arms. That's more than 4 feet.
Right. Wow. So they are really making it way more feasible to put those ADUs on your property, essentially.
That's the government restrictions.
Right.
Then you go into the CC&Rs, and if you live in California, you're probably pretty used to living in homeowners associations that have conditions, covenants, and restrictions, otherwise known as CC&Rs. There are basically a bunch of rules of what you can and cannot do as a homeowner in one of these communities. The law with respect to homeowners associations, to me, is where there's a lot of gray area.
Gotcha.
And you're going to see a lot of
resistance, right?
Well, of course you are. I mean, can you imagine? I mean, if some people are living in associations with CC&Rs on purpose, right? Because they want to regulate what the community looks like.
I mean, I'm sure people in Newport or Yorba Linda are going to love their neighbor putting 2 ADUs on their property and just overflowing that parking structure, right?
Yeah, exactly. So you can imagine how there's going to be a lot of pushback. And basically my interpretation of the law with respect to homeowners associations is that the homeowners association is allowed to regulate the property and ADUs so long as it's reasonable.
Gotcha.
I mean, you could open up the case books. In fact, we're in my office and you can't see it because it's off camera, but there's a whole bookshelf full of case books that deal with what is a reasonable interpretation of the law. So you can imagine how much litigation there's going to be trying to decide what is reasonable and what is unreasonable.
Gotcha.
So it's going to be, in my mind, potentially the Wild West of litigation with respect to what homeowners associations are going to deem reasonable restrictions.
So essentially, if you are intending on putting an ADU on your property, it might be best to do so if you're not in an HOA, unless you want to get a bunch of pushback, because that is a possibility.
I think it's going to be much easier if you're not in an HOA to build your ADU. In fact, I'm already seeing a lot of cities just have pre-approved plans that are just ready to go. Go ahead, and if you're willing to build one of these, submit your application, and 60 days later, you should have your approved plans and you're off to the races. You're building your project.
That's the other thing that they made easier, right? It's way quicker to get your permits approved because they no longer can have you wait 120 days. It's 60 days. 60 days.
They have to process the ADU permit application within 60 days.
Okay, and then now say if you just have a prefab structure, it's literally plug and play, drop it into your house.
Absolutely, yeah. In fact, there's a lot of these kind of interesting prefabbed development or manufacturers that are out there that are taking, for example, like cargo ship containers and turning those into really unique looking structures. And the manufactured home, or like what everyone's referred to kind of derogatorily for the years as the mobile home type of, prefabbed home. Yeah, there's a lot of those companies that have already looked at these laws and are developing these things just to have them ready to go. Just buy them. It'll be delivered on a truck and you can drop it into your backyard and hook it up to the utilities pretty quick. Another interesting thing to think about too, if you're going to build an ADU you're living in an HOA, is it's a 2-step process now to do this. One, you still have to pull your permit from the governmental, agency. So if it's a city, the local building department, or if it's controlled by the county, then you're going to go to the county and pull your permit there. But you still have to comply with the association requirements too. Just because this law has been passed doesn't mean that the association requirements no longer apply. So there still is a requirement that you have to submit an application to the architectural committee of the association. They can approve it or not approve it. By the way, the 60-day time period does not expressly apply to an HOA. So although the city has to approve your permit in 60 days, I didn't see that in the statute as to the homeowners association.
Gotcha.
So there's a whole different time that might apply to getting your homeowners association to approve you. And your homeowners association might have different considerations than what the city might take into consideration. For example, homeowners associations in some cases limit the development in such strict ways that they determine what paint colors you're going to use.
Wow.
What the roofing materials are to look like. Literally they want everything to look very uniform. That's why people move to those types of places. So you still might have to comply with those things and go through that process through your association. And again, I mentioned the standard for what the association does is whether it's unreasonable, and that's completely undefined.
It's a huge gray area that can definitely be manipulated by the HOAs to prevent those ADUs being dumped into their neighborhoods. And so the city has made it so that you don't have to get pay fees as long as an ADU is 750 square feet or less. So the HOA could easily tack on fees, I'm assuming, for these HOA or for these ADUs if they want to.
Meaning what homeowners association dues?
Yes.
I don't think they're going to be able to raise the association dues, but I mean, I would imagine if they have rules in place, homeowners associations are given wide latitude in how they govern their communities. So if they're going to charge application fees, they can make those fees probably pretty much what they want to make them within reason.
That makes sense. For all those people living in HOAs, there's a little burden of relief that you might be a little more protected than say someone not living in an HOA.
Well, let me give you a specific example of something that I could see happening. Like I had a case not that long ago in Newport Beach.
Okay.
And the HOA there had guaranteed view rights. It was important for these people to all have their ocean views. I mean, who can blame them, right?
Yes.
They're spending millions of dollars. That's what they're paying for. So this particular development said, if you're going to make any improvements to your property, that one, you have to submit your application. Two, you have to put up a story pole, which is essentially you put up sticks with streamers across them to show the rest of the community what your new structure is going to look like visually from a height and width standpoint. So I would think that those types of regulations that protect people's views and give homeowners the right to voice dissent to whatever it is you're going to build would still apply. So you would still have to put up the story poles, for example, in this particular community in Newport Beach that has these rules.
Right.
And the homeowners would then look at it all and then have an opportunity to basically
vote on
object.
it.
Yeah. So that's where you're going to get into what a reasonable restriction is. Sure, you can build the ADU, but if it also then violates the view right that exists within this association, are you going to be allowed to build this particular ADU? Maybe, maybe not.
Gotcha. So even though the laws say that HOAs cannot push back against it, there are still some sort of loophole to make it so that they can.
Reasonable restrictions.
Reasonable restrictions.
Right.
Okay. Wow. So not to kind of cross over with laws, but there was another law that got passed, which is more of a rent control law that is kind of dictating where the rent cap in California. Now that SFRs are becoming more of like triplexes. So would this make it so that if you say you lived in your own property and would that become a rent control dwelling essentially?
Well, if you're living in your own property, it's rent controlled if you decide you're going to rent the whole house out. So for example, if you rent a bedroom, you're not subject to the rent controls. But if you take your house and turn it into a situation where you're going to move out and then rent the whole property out, it is now subject to what everybody's calling this rent control statute. So if you end up having let's say a family's rented it, and that family has now been in your property as a tenant for more than 12 years, you're now subject to the requirements of what everyone's calling the rent control statute. And essentially what this is that you can't raise the rent more than 5% in 1 year,
right,
plus whatever the cost of living increase is. So there's various indexes out there that kind of publish what cost of living is and what the increase is. It never goes down, so I'm just going to call it an increase. So if the cost of living increase is 3%, and the statute allows you to raise the rent no more than 5% beyond that, you can then raise the rent 8% in a year, assuming the cost of living increase is 3%.
So now getting back to our previous subject, now we've stated rent control. Now say you live in a house and you put 2 ADUs on your property. Are those back to ADUs now subject to rent control since they're not technically part of your unit? They're actually a triplex, and under the rent control law, if you have a triplex, that is a rent control property.
Right. That's a great question, and I think the law is a little bit ambiguous on this, but if I was to be advising a client on what that ADU is going to be, especially if it's the case of being a fully detached structure in the backyard, for example, that's going to be subject to the rent control.
Gotcha. Okay. So ADUs, possibly rent control units. Rob, any other insight you might have about these laws that are making it so people can put ADUs in their property?
You know, I would just say make sure that you familiarize yourself with what the laws are before you do something. talk to a professional before you commit yourself
Absolutely.
to something, and know what you're getting into, because especially in the rent control situation, if you're going to be a landlord and rent your property, you better know what these new laws are, because there's penalties for not knowing what they are, and you can end up taking a situation where you're maybe trying to increase your rent by $400 or $500 a month, and you're going to put yourself in a situation where you're going to end up paying 100 times that in penalties and attorney's fees for not knowing what the law was and making a decision ignorantly.
Absolutely, no doubt. Seeking professional legal advice is always advised. Rob, thank you so much for coming on. I really appreciate it.
Appreciate it. Good seeing you.
Good seeing you too. Cool.
Should I take this off now? That was
it.
All right, right on. Yeah, the ADU thing is cool. I'm like kind of excited about that.
Dude,
really.